Good evening, dear children. In our previous class, we have learned about police duties and functions. And in today's class, we will be learning about the various methods of criminal investigation. When we file a complaint or when a cognizable offense occurs, first thing the police do is to register the complaint and serve a copy of the same to the complainant. So in the case of cognizable offense, a police officer can commence the investigation immediately, which means even without the order of the magistrate. So it is wide and absolute. We can say that the process of investigation starts as soon as it comes into the notice of the police officer. The police officer must satisfy himself that there is sufficient reason for starting the investigation. Now let's see the literal meaning of the term investigation. When we hear the term investigation, it gives us some sort of thrill that we are going to find something, isn't it? So similarly, the definition of investigation is that conducting a search for facts of materials to find out whether any offense, cognizable or non-cognizable, has been committed. Investigation includes the proceedings that involve in collection of evidence by a police officer. It is for finding out the base of the case and to provide justice to the innocent party. The very first step in the investigation is always finding out the facts and circumstances of the case. And it is the duty of the police officer to bring out the real truth before the court of justice. There are various steps involved in police investigation. Those are: first one, filing of FIR. Second is proceeding to the spot. Then identifying physical evidence. Investigating and determining facts of the case. Then next step is evidence collection and evidence protection. The last and final step is taking measures to arrest the offender. So these are the various steps involved in criminal investigation. Keeping in mind that these are very essential tasks that needs to be practiced with high degree of skill to avail maximum amount of accurate information in the investigation process. Now let's see these steps one by one. The first one is filing of FIR. As I have mentioned earlier, the first thing police officer will do is lodging an FIR. So as soon as a cognizable offense comes into his notice, he will lodge an FIR. This is explained under section 154 clause 1 of CRPC. 154 clause 1 of CRPC says that every information relating to the commission of cognizable offense, if given orally to an officer in charge of police station, shall be reduced to writing by him or under his direction and be read over to the informant. And every such information, whether given in writing or reduced to writing as aforesaid, shall be signed by the person giving it, and the substances thereof shall be entered into a book to be kept by such officer in such form as the state government may prescribe in this behalf. So whether the information given in writing or not, it should be reduced to writing, then to be signed by the informant, and this is the first procedure, and copy of which should be given to the informant. If the offense is non-cognizable, then as per section 155 of CRPC, the officer in charge of the police station shall record the information in a book kept for that purpose and refer the informant to the magistrate. A police officer shall not investigate a non-cognizable offense without the order of the magistrate. It's very, very important. But in the case of cognizable offense, after the registration of FIR, the police officer may commence the investigation by himself. This is mentioned under section 156 clause 1 of CRPC or under the order of a magistrate. Hence, as I have mentioned earlier, in the case of cognizable offense, the power of police officer to commence the investigation is wide and absolute. The officer has the absolute freedom to investigate the case. However, if the police officer surpasses his limit, improperly or illegally exercise his power during the course of investigation, then the court can consider it as a breach of duty and may take in hand the procedure for further investigating that offense. So we saw the first step, filing of FIR. The next step is proceeding to the spot. So after collecting all necessary information from the informant, the next step a police officer will do is to send a report to the magistrate who has the power to take the cognizance of that offense. In case of cognizable offense, he can start the investigation immediately without the order of the magistrate. And as per section 157 clause 1 of CRPC, the next step is proceeding to the spot. An officer in charge of the police station shall proceed to the spot to investigate the facts and circumstances of the case and to make necessary measures or the discovery of the arrest of the offender. There are some exceptions to do this. They are like if the matter is not of serious nature, and next one is if there is no sufficient ground for investigation. So in these circumstances, the officer, means the police officer, shall state the reason for not investigating and inform the same to the informant. Further, as per section 158 of CRPC, the report that is prepared by the officer in charge submit to the superior officer appointed by the government and may give instruction to the officer in charge and record that instruction in the report and submit the report to the magistrate. And also under section 159 of CRPC, the magistrate has the power to direct any subordinate to conduct the investigation by himself. So the second step is also over, proceeding to the spot. Next one is identifying physical evidence. We know the physical evidence includes the collection of every material or substances related to the case or recording of statements associated with the parties of the case. It includes blood, semen, fingerprint, etc. This is as a valid evidence to the case, and we know that other than these physical evidence, there are documentary evidence also, like something that exists in paper or in electronic form. Also, we know that there are circumstantial evidence, that is like fact collected during the time of investigation at a spot where the crime ought to have been committed. These are very helpful in determining the case deeply. Also, we know about hearsay evidence, and we know that in front of court of law, the hearsay evidence is not acceptable. So the steps, like after filing FIR and then proceeding to the spot for finding all the necessary piece of evidence, suspects and witness, the police officer has the authority to call any person who appears to be acquainted with the facts and circumstances of the case to be present for interrogation. Any person having first-hand information of the crime can be a witness, and they are obliged to state correct and true facts relating to the matter, because their statement matter a lot in the case. The power to identify and address a witness is explained under section 160 of CRPC. Section 160 of CRPC states like this: any police officer making investigation may require the attendance of any person who appears to be acquainted with the facts and circumstances of the case. So after collecting all the evidence, next step is investigating and determining the facts of the case. In order to understand the facts of the case, any police officer who is in charge of the investigation is empowered to examine a witness or a person who is acquainted or aware of the facts and circumstances of the case. And this is explained under section 161 of CRPC. As per section 161 clause 1, a police officer in charge may examine orally any person supposed to be acquainted with the facts and circumstances of the case. The statements of witnesses are important as they can make a person guilty or innocent. The person who are being investigated are expected and bound to answer truly all the questions relating to such case that is put before him. They are not bound to truly answer the questions which would expose them to a criminal charge or any other charge. After the examination, the police officer making the investigation shall reduce the number of statements given by the person in the course of the examination. And if done so, he shall keep a separate record of the same. As per section 162 of CRPC, which states that these statements which are given to the police officer and later reduced to writing needn't be signed. Statements made to the police officer should be of free will, and this is mentioned under section 163 of CRPC. And further, section 164 of CRPC explains about the confession made to the magistrates. There are two conditions explained for that. One is the only magistrate has the power to take such statement after intimating that this could be used as an evidence against the person making it. Second condition is that the confession must be made voluntarily. There shouldn't be any sort of pressure. So after this, the next step is evidence collection and evidence protection. As per section 165 of CRPC, a police officer is empowered to search for any place which he has a reasonable ground to believe that that place contains necessary evidence with respect to the investigation he is authorized to make. A police officer has to record in writing, first one is his reason for the search, the place to be searched, and the thing he has to be searched in that place. After that, after which he proceeds in person. If the police officer is unable to do the search by himself, then he may, in writing or by order, his subordinate officer to conduct that search. He can ask his subordinate to conduct that search, or to direct him to the place to be searched and the thing to be searched, or the substance he has to find out. And then the subordinate officer can then conduct the search on the basis of the written order given to him. So for conducting that search by the subordinate officer, he should get an order from his superior officer. The officer should make a record of the search done and send the report to the same to the nearest magistrate, who can further furnish it to the owner or the occupier of the place where the search can be conducted free of cost. That is on application. If the person apply for that, then it can be sent. These things are explained under section 165 of CRPC. And as per section 167 of CRPC, the accused or arrested person cannot be detained more than 24 hours. And there are certain procedures prescribed in this section which needs to be taken if the investigation cannot be completed within 24 hours. They are like when the accused is arrested without a warrant and is detained by the police officer in his custody. Next one is it is passed more than 24 hours for an investigation. And these are grounds to believe that these are the things and there is a ground to believe that the accusation or the information against him is well founded. Then the officer in charge of the police office or a police station or the investigation officer not below the rank of sub-inspector forward the accused for remand before the magistrate. So the final step we will do is next is taking measures to arrest the offender. So the basic procedure for making an arrest is mentioned under section 46 of CRPC. Subsection 1 of this section, section 46, provides that arresting authority has to actually touch or confine the body of the person to be arrested. And also they can be submitted to a custody by words or by action. For instance, if a person himself walks to the police station and surrenders, he will be considered under an arrester. Further, subsection 2 says that if a person forcibly resists the arresting authority and attempts to evade the arrest, then the arresting authority has the power to use all such manners to prevent such an escape. One more thing to remember is that not only police officer but also various other authorities have powers to arrest an individual. These are mentioned under relevant sections in CRPC, such as private person or a magistrate, of course police officer. So these people are empowered to make an arrest. So in today's class we have learned various methods of investigation, which includes filing of FIR, then proceeding to the spot, then to identify evidence, investigate and determine the facts of the case, evidence collection, evidence protection, finally to arrest the offender. Hope all of you have understand my class, and this is all for today. See you in the next class. Thank you.